on the face of the petition, tribal issues have been raised. These issues could be issues of fact, law, or both law and fact. We think that once the court is satisfied that the issues raised in an originating process, such as a petition or a writ, is not frivolous, then a cause of action has been disclosed to invoke the jurisdiction of the court. In the case of the Asibre Asariba the second and 4 others versus Attorney General, 2010 Supreme Court of Ghana Law Report 463. This court, speaking through Judge Nawood CJ, stated that to identify the real substance of actions brought before the court, we have observed that the proper approach is to examine the writs as well as the pleadings in this type of litigation, the reliefs and the facts verified by the affidavit. End of quote. Further, it is always the duty of the court not to assume jurisdiction over a suit where the court has no jurisdiction over either the subject matter of the suit, the parties to the action, or where a party to the suit is not clothed with capacity regarding the subject matter in issue. Again, a court may not assume jurisdiction over a case where issues of limitation, estoppel, per rem judicata are raised and proof as preliminary points. In the circumstances of any of the above being applicable, the court ought not to assume jurisdiction to determine the merits of the case before it. In the absence of the existence of any of these factors, the court decided to incorporate its ruling on this issue in its final judgment. In this petition, the petitioner was one of the candidates who contested the presidential election held on 7th of December 2020 and thus had the right to challenge the validity of the results declared by the chairperson of the first respondent if he is so aggrieved. The petitioner by this petition is challenging the act of the chairperson of the first respondent, declaring the second respondent the winner of the elections on grounds that the second respondent did not cross the constitutional threshold of more than 50% votes. The petitioner has also alleged wrong aggregation of votes and vote padding by officers of the first respondent in favor of the second respondent. We are of the opinion that these allegations relate to the integrity of the election and, if proved, may impact the validity of the election. The allegations thus provide enough grounds for the invocation of the jurisdiction of this court and Article 64 of the 1992 Constitution, and thus confer on the petitioner a course of action to initiate the action. The second respondent at paragraph 23 of his written submissions in support of the preliminary objection did concede that the allegation of wrong aggregation of votes and vote padding could be described as irregularities in an action, but the number in an election, but the number of votes involved in the allegations cannot materially affect the outcome of the election. On this concession, as well as our own thinking, we are convinced that the petition discloses a reasonable course of action. We wish to state that a court called upon to decide whether or not a party has a course of action must not dwell so much on the strength of that party's case, since that can only be determined if the matter is submitted to trial. For example, in this petition, the court must assume jurisdiction in order to determine whether the averments regarding the declaration of results and the issue of CI 135 are sustainable in law, whether there was vote padding, and if so, whether it had any impact on the results declared by the chairperson of the first respondent. On this issue, therefore, the argument that the petitioner must have a weak case On this issue, therefore, the argument that the petitioner may have a weak case is no good ground to summarily dismiss the petition as contended by the respondent. See Appear, Disicam versus Boachi, 1993-94, 1 Ghana Report 417, where this court held that whenever the pleadings in the case raise some questions fit to be decided by evidence, the mere fact that the party's case or defense might be weak would be no ground for striking it out. On this point, we agree with the decision in the oft-quoted case of Dyson versus Attorney General, 1911 1 KB 410, cited by counsel for the petitioner on terminating proceedings without preliminary trial. In that case, Moulton LJ said at page 419 that, quote, the court will not permit a plaintiff to be driven from the judgment seat without considering his right to be heard, except in cases where the course of action is obviously and almost incontestably bad, end of quote. Having carefully considered the pleadings, especially the constitutional provisions referred to and the issues raised by the parties, it is our view that this petition is not incontestably bad in law or frivolous and vexatious, such that it ought to be summarily dismissed. Any alleged breach of the fundamental law of the land must be carefully examined by this court, as the only court clothed with jurisdiction to do so. It is on the basis of these reasons that we hold that the preliminary objection raised by the respondent herein should be overruled for the petition to be determined on the merits. Validity of the declaration of the results of the presidential election, that is issue 2. We now address issue 2, which is whether or not, based on the data obtained in the declaration by the first, we will now address issue 2, which is whether or not, based on the data contained in the declaration by the first respondent of the second respondent as president-elect, no candidate obtained more than 50% of the valid vote cast as required by Article 63(3) of the 1992 Constitution. The source of this issue could be traced to the errors in the declaration made by the chairperson of the first respondent on the 9th December 2020. In that declaration, which was tendered as Exhibit A by PW1, Mr. Asiedun Ketia, the chairperson of the first respondent, was seen and heard giving the particulars of the total votes of each of the 12 candidates obtained at the end of the polls, excluding the votes from Techim and South constituency, which was still outstanding. There is no doubt that in providing particulars of the votes cast, the chairperson of the first respondent announced the figure 13,434,574 when he was referring to total valid votes cast, which was in actuality 13,121,111. As a result of this erroneous reference, the petitioner pleaded at paragraph 6, 7, 8, 9, and 10 of the petition, which are reproduced as follows. Quote 6. Purporting to declare the results, Mrs. Jean Adokwe-Mensah, chairperson of first respondent and returning officer for the presidential election, said, at the end of the transparent, fair, orderly, timely and peaceful presidential elections, the total number of valid votes cast was 13,434,574, representing 79% of the total registered voters. 7. In the declaration, Mrs. Jean Adokwe-Mensah, chairperson of first respondent and the returning officer for the presidential election, further said that second respondent of the NPP obtained 6,730,413 votes, being 51.595% of the total valid votes cast. 8. The claim that the percentage of the total votes cast was 51.595% of the total valid votes, that she herself distinctly stated to have been 13,434,574, was manifest error, and votes cast for second respondent would amount to 50% and not the 51.95% erroneously declared. 9. Mrs. Jean Adokwe-Mensah, chairperson of first respondent and the returning officer for the presidential, John Ramani Mahama of NDC obtained 6,214,899 votes, being 47.366% of the total valid votes cast. 10. From the total valid votes cast of 13,434,574, the petitioner's percentage will be 46.260% and not 46.260% and not the 47.366% erroneously declared. End of quote. From the evidence on record, it seems the petitioner built his case around this figure of 13,434,574, erroneously announced by the chairperson of first respondent as the total valid votes cast. The description she gave to this figure was wrong. Exhibit A, which is a video clip of the declaration gave details of all the votes obtained by all the presidential candidates, and this gave a total valid votes cast of 13,121,111. Out of this figure, the second respondent, Nana Akufo-Addo, of the NPP, obtained 6,630,730,413, while the petitioner, John Dramani Mahama, obtained 6,214,889. The evidence on record is that the chairperson of first respondent, having detected the error in announcing the figure of 30,434,574 as the total valid votes cast, corrected the error and issued a press release on the 10th of December 2020. The thrust of the issue under consideration is the error in the description of figures quoted by the chairperson of first respondent while declaring the results of the presidential election. In this petition, evidence has been adduced through PW1, Mr. Seyedun Ketia, to show that the actual total valid vote cast, excluding the votes from Techiman South, at the time the declaration was made, was 30,121,111. This figure has been admitted by the petitioner in paragraph 12 of his petition, which reads as follows, quote, if the total number of valid votes standing to the names of each of the presidential candidates is summed up, this would yield a total number of valid votes cast of 30,121,111, a figure that is completely missing from the purported declaration by Mrs. Jane Adukwe Mensah on 9th December 2020 and the purported rectification on 10th December 2020. End of quote. In law, a party is bound by his pleadings, and the only way he could free himself from the amendment in the pleading is through amendment. See Hammond and Adoi. Hammond and Odoi, 1982-83, through Ghana Report, page 1215. The above pleading was supported by the evidence of PW and Mr. Seyedun Ketia while under co-examination on the 1st of February 2021 by counsel for the second respondent. The relevant part of the co-examination is reproduced below. Question: I am saying that from the declaration in the video clip that we just saw, which really is